You see, while Malibu's appeal was pending in court, something interesting happened. Take a look at this. The federal government's lawyers, Babalaki and Co., wrote to Mr. Bayojo, the Attorney General of the Federation, to raise a point of law, warning that the federal government might lose a case and it will be costly. Well, on receiving the letter, Ojo wrote to Dr. Edmond Dalcoru, who was a Minister of State for Petroleum Resources, asking for an out-of-court settlement, of course based on Babalaki and Co.'s advice. And on October the 3rd, 2006, Dalcoru wrote to President Obasanjo to inform him of the proposed out-of-court settlement and to seek his approval to proceed with it.
Dalcoru wrote, "In the light of the above, Mr. President is respectfully invited to approve the proposal for out-of-court settlement of the suit brought by Malabu in respect of OPL245 as outlined."
And President Obasanjo wrote, "Minister of State, approved." On November the 30th, 2006, the settlement agreement was signed by the federal government and Malabu. It was then registered as a consent judgment of the Federal High Court. The terms of the settlement agreement were that the federal government would reallocate Block 245 to Malabu in the spirit of amicable settlement and without any admission of liability for any alleged wrongful, unlawful, unjust, or any like conduct. That the new signature bonus shall be $210 million. But since Malabu had earlier paid $2,040,000, the balance will be $207,960,000 payable within 12 months after the execution of the agreement. That Malabu could assign Block 245 or any part of it in accordance with the provisions of the Petroleum Act. That Malabu shall not raise any issues or bring any court action again regarding losses, liabilities, or damages over the revocation of Block 245. That Malabu shall terminate its case at the Court of Appeal after the execution of the settlement agreement. On December the 2nd, 2006, Dalcoru wrote to Etete to confirm that the settlement agreement had been approved by Obasanjo. Dalcoru also informed Shell Ultra Deep that as part of the settlement, the oil company will be awarded another block with comparable potential and hydrocarbon prospectivity. And following this, Malabu discontinued its case at the Court of Appeal on January the 16th, 2007. But that's not all. You see, years later, then President Obasanjo would deny approving that agreement. And the settlement agreement was just another lap in the long-distance race. Shell Ultra Deep was predictably injured. By the turn of events, it had a good claim on the federal government because it had been assured that all was well before it went ahead to de-risk its investment in the block. And now, OPL245 was gone again. Its next step? Shell said it held a meeting with Obasanjo in February 2007, where it was agreed that Malabu should be given a share of NNPC's 60% stake in the block. Malabu rejected the offer, insisting on the implementation of the settlement agreement. In April 2007, Shell Ultra Deep filed a notice of arbitration against Nigeria at the International Center for the Settlement of Investment Disputes, an organ of the World Bank. It demanded a compensation of $1.8 billion, alleging expropriation of its estimated investment of $500 million. In his last days in office, Obasanjo wrote to Dalcoru, seeking to clarify his position. He said Shell Ultra Deep should remain the contractor, having de-risked the block, while Malabu and NNPC will be the concessionaires as co-owners. And when President Umar Musa Yar'Adua, when he assumed office in May 2007, the OPL245 saga was one of the issues he inherited from the Obasanjo administration. So in August 2007, Yar'Adua set up an interministerial committee to resolve the dispute in a way that would accommodate the interests of both Malabu and Shell Ultra Deep. Now, part of the proposal was to compensate Shell with an oil block with equivalent of 50% of Block 245, but Shell rejected the offer. And in comes Dr. Goodluck Jonathan, who became president after the death of Yar'Adua.
but he was barely a week in office when on May 11, 2010, Malibu wrote a letter to him asking the new administration to implement the 2006 settlement agreement, which was entered into by the Obasanjo administration. Well, the letter was signed by Mr. Raskik Benige, who's Malibu's company secretary and legal advisor. So what did Jonathan do? Well, he asked Mr. Mohammed Bello Adoke, the Attorney General, for legal opinion on the settlement agreement. And in his response, Adoke said he had reviewed all the relevant documents, and his opinion was that the 2006 agreement was subsisting and enforceable. So Jonathan decided to implement the 2006 settlement agreement.
This was communicated to Malibu by Mrs. Dezani Alison Madueke, Minister of Petroleum Resources, via letter dated July 2, 2010, ironically on the 9th anniversary of the Block 245 revocation. Still, this did not resolve the problem, as Malibu and Shell still bore historical grudges against each other. In fact, Shell had an outstanding arbitration award of $20 million against Malibu,
and had also launched an arbitration proceedings against the Nigerian government over the 2006 settlement agreement. That should have been the end of the story, right? But no, this story is far from over, because after the return of OPL245 to Malibu,
Malibu engaged the services of middlemen to market the block, indicating that it was ready to sell off its entire interest. Mr. Adnan Agaev, a former Russian intelligence officer, had introduced Mr. Emeka Obi, a Nigerian businessman, to Malibu in December 2009 to help it find buyers. And that's even before the block was returned to the government.
Eni, an Italian company, indicated interest in acquiring the block. Well, Shell was still interested as well, having invested hundreds of millions of dollars in developing the acreage. Malibu was no longer interested in doing business with Shell because of the bitter history between them, and Eni could not go ahead with its interest because of Shell's position. Deadlock. So the parties approached the federal government, asking it to broker a resolution of the crisis of confidence. Shell and Eni offered to acquire Malibu's 100% in Block 245, and after a series of negotiations and meetings by all the parties, a number of resolutions were reached. 1. Malibu and Shell Ultra Deep agreed to terminate all the court and arbitration proceedings regarding OPL245. 2. Malibu agreed to relinquish its entire interest in OPL245 for a compensation of $1.092 billion. 3. Federal government agreed to indemnify Shell and Eni against future claims on the oil block. And 4. Shell and Eni agreed to pay the agreed price of $1.092 billion to the Nigerian account at JP Morgan in London, in addition to the $210 million signature bonus. In all, the payments came to $1.3 billion. But let's backtrack a bit. Now recall that in December 2003, Shell Ultra Deep had paid $1 million of the signature bonus and deposited the balance of $209 million in an escrow account at JP Morgan Bank, and that was pending the resolution of the dispute. As disclosed later, contributions from Shell entities amounted to just under $320 million, including the release of the signature bonus from the escrow account. Now, Eni contributed the remainder $980 million. But there's one more detail. Before the Block 245 resolution agreements were signed, Mr. Andrew Obaje, who was the then director of the Department of Petroleum Resources, raised an objection over the non-provision for a back-in right for Nigeria. Now, what is a back-in right? Well, a back-in right would allow the country to take a share in the oil block in the future. A committee was set up to look into Mr. Obaje's objection, and the back-in right provision was inserted. So on April 29, 2011, Malibu, Shell, Eni and the federal government of Nigeria signed the suite of agreements known as Block 245 Resolution Agreements. So it appeared the whole controversy had finally ended. But another phase started after the execution of the resolution agreements. And so, the federal government instructed JP Morgan to transfer Malibu's $1.1 billion to the account of Petrol Services Company Limited with BML. That's a bank in Lebanon. Now, that was the account provided by Malibu. On May the 25th, 2011, JP Morgan tried to transfer the money, but the Lebanese bank rejected the transfer. And that was the first red flag. On June the 15th, 2011, Malibu wrote to the Nigerian Minister of State for Finance, Dr. Yerima Lawan Ngama, to inform him of a development. And Malibu then provided its Nigerian bank accounts, which Ngama then communicated to JP Morgan. But another problem was brewing. In July 2011, it emerged that Malibu was having a running battle with its own partners, who said they were middlemen and consultants in the OPL245 transaction, and they wanted their payment.
MKLB's company, Energy Ventures Partners EVP Limited, had on July 18, 2011 secured an ex parte order from a UK court, freezing $200 million of Malibu's money. He alleged that there was a verbal agreement to pay him that amount as finder's fee. He also asked the court to award $15 million to him as cost. JP Morgan was served that freezing order. A second company, International Legal Consulting Limited, a Swiss entity owned by Agave, then sued Malibu for $65 million in the US. Agave, Obi's friend, claimed he was entitled to 6% of the payment to Malibu.
Well, the bank got in touch with the Nigerian government over the court order. Officials of the Finance Ministry referred the letter to Adoke, the Attorney General, and asked for his legal advice. In his response dated July the 8th, 2011, Adoke advised the ministry that a court order should be obeyed regarding the sums to be frozen and the unencumbered amount could be transferred to Malibu's nominated account. Well, officials of the Ministry of Finance thereafter instructed JP Morgan to transfer a total of $875 million to Malibu's bank accounts in Nigeria and to withhold the balance pending the outcome of the court proceedings. But JP Morgan also sought and got the approval of the UK Serious Organised Crime Office before transferring $401,540,000 to Malibu's account with First Bank of Nigeria PLC and $400 million to its account with Keystone Bank. Well, that happened on August 23rd, 2011. The balance of $290 million was withheld by JP Morgan, but the court cases eventually went in Malibu's favor. You see, telling the OPL story is definitely taking its toll, hence the need for some room to stretch, because with the OPL245, nothing is ever done and dusted. At every turn, there is always a new controversy, and what happens next turned global attention to OPL245 and led to what anti-corruption campaigners called the world's biggest corporate fraud trial. A coalition of international NGOs had started raising issues after Block 245 resolution agreements were signed in April 2011. They alleged money laundering and international corruption. They were particularly alarmed at the involvement of Etete, especially as he had been convicted of money laundering in France in 2007. It said Malibu was engaged in criminality, reporting that it was registered using a fictitious character and that it maintained a fake address with the Corporate Affairs Commission. And this marks the birth of a Malibu scandal in media reportage. They alleged as follows: that OPL245 was unlawfully acquired by Etete when he was a Minister of Petroleum Resources, and that his interest in OPL245 was held through Malibu. That Eni negotiated and participated in a corrupt agreement that enabled Etete to crystallize and launder these illegally obtained assets through a convoluted deal that resulted in a consortium of Eni and Shell acquiring OPL245 through the resolution agreement of April 2011. That the belief that both Etete and the son of General Abacha were shareholders when the oil block was awarded raised the concern that the award of OPL245 was a way for Nigeria's ruling elites to profit illicitly from the country's natural resources. There's a long list. The next one is that after the death of Abacha, Etete reportedly increased his shareholding in Malibu, fraudulently taking control of 100% of the company, and that Mohamed Abacha had petitioned the EFCC to investigate the matter in January 2012. Well, the Corner House and Global Witness also petitioned the Metropolitan Police Service in London to look into the OPL245 transaction. The international NGO's partners in Nigeria were Header Resource Center and Premium Times. So in September 2013, Recommon, the Corner House, and Global Witness made a significant headway when they sent a similar petition to the Public Prosecutor's Office in Milan, Italy. Don't forget that Eni is an Italian company. So on December the 20th, 2017, the Court of Milan issued a decree ordering the indictment of 15 individuals and entities, including Shell, Eni, Etete, and some former employees of the oil companies. They were ordered to appear before the 10th Division of the Court of Milan at the commencement of the hearing, scheduled for March the 5th, 2018. When Nigeria joined the lawsuit as the injured civil party, the prosecutors filed separate charges against Mr. Emeka Obi, a CEO of Energy Venture Partners, and Alhaji Aliyu Abubakar, who's a Nigerian property developer, accused of being the conduit through which bribes were shared to government officials. The same month, Nigeria filed a civil suit against JP Morgan in a UK court seeking a $1.7 billion compensation from the bank for transferring $875 million to Malibu in 2011. Now see what happened. Nigeria invoked the Queen's Care Duty Doctrine, arguing that JP Morgan should have known that the money transferred to Malibu was part of a fraudulent scheme. But in Nigeria, the EFCC filed court cases against Adoke, Aliyu, Binige, Malibu, Ajib, same as Eni, Shell Nigeria Exploration, and Shell Ultra Deep. A long list, alleging corruption, money laundering, and conspiracy to commit forgery. So, Malibu scandal started to feature prominently in the Nigerian media coverage of the court proceedings.